store facility managers and others, and the governing body of Christ the King College and others.
My lady and my lords, I appear on behalf of the appellant, Christ the King College, who I'll refer to as the college in my submission. My learned friends, Mr. Salzido, Queen's Counsel, and Ms. Dutton, appear on behalf of the respondents. Before I go any further, there are two housekeeping matters I just wanted to address. The first is a minor point, but I wanted to check with your lordships and my lady that you're okay with me sitting on the front row.
Of course.
There being only one row, I think,
of course.
for advocates at the moment. The second was just a timekeeping issue. I spoke with my learned friend, Mr. Salzido, yesterday, and our current feeling is the appeal may not require the full 2 days, and that we may be able to finish within a day and a half, and possibly sooner, but that may depend on how things go.
Well, that's very helpful indeed. It's fair to say I questioned whether 2 days was going to be more than enough, but on the other hand, it is important that each of you has a proper opportunity to make the points you wish to make.
I'm grateful.
But thank you very much for the indication.
With those 2 points to one side, as you know, this appeal concerns a narrow but important question about the proper approach to restitution of reciprocal benefits conferred pursuant to a void finance lease. The hallmark of a finance lease is that the contract involves transferring substantially all the risks and rewards incidental to the ownership of the asset to the lessee. In substance, therefore, although the contract was structured as a 15-year lease, it was in reality a transaction under which the college acquired the building through taking out a loan from the respondents, which it was to repay in a number of instalments, together with interest. Now, the contract was void because the college did not have capacity to enter into any form of borrowing without the permission of the Secretary of State for Education, which was neither sought nor obtained. And there is no appeal against that part of the judgment. In circumstances where the contract was void, each party brought claims against the other, seeking return of the benefits which were conferred under the contract. Now, on the one side, my clients, the college, paid the first respondent, who I'll call SFM, a sum of approximately £3.2 million. In return, the college obtained the benefit of the use of the building, which was valued at approximately £1.7 million. And the figures and the references are all set out in Annex A to my skeleton argument, which is at Core Bundle tab 2, page 36, but there's no need to turn that up for the time being. The respondents were refused permission to challenge the judge's approach to the valuation of the benefit of the use of the building, and they have rightly abandoned the respondent's notice, which sought to raise the same point. So the respondent's notice is no longer live on this appeal either. It follows that the value of the payments made by the college exceeded the value to the college of the use of the building by almost £1.5 million. And in other words, SFM received a net benefit at the college's expense. It's my respectful submission on this appeal that the correct approach in law at this stage of the analysis was for the benefits going both ways to be netted off against one another, leaving a single claim by the college against SFM for the net benefit which it received, which was for roughly 1.5 million. And this is referred to in my submissions as the counter-restitution principle, and it is the central issue in this appeal. In summary, the relevant principle is that where benefits are conferred both ways, pursuant to an exchange transaction like this, which fails, each party cannot generally recover in unjust enrichment from the other without first giving back what it has received in return.
Sorry, could you just say that again? So,
yes.
when benefits are conferred both ways pursuant to an exchange transaction.
Yes, which has failed in this instance because it is void. Yes. Each party cannot generally recover in unjust enrichment from the other without first giving back what it has received in return.
Cannot generally.
Cannot generally.
And where does that leave the building?
The building is that is what the college has paid for the use of.
And who has ownership of it now?
It's still owned, as I understand it, by SFM.
And who's using it now?
Could I just take instructions on that for 2 seconds? My lord, although this concerns matters subsequent to the judgment, it's no longer being used.
Thank you.
Now, it is also my submission that this principle applies before any question can arise as to whether the party who received a net benefit might have some other defence to a claim in unjust enrichment for return of that benefit, such as the change of position defence. If the judge had applied this approach, then he would have netted off the 3.2 million received by SFM against the 1.7 million benefit received by the college, leaving a single claim by the college against SFM for restitution of approximately 1.5 million. That claim would then have been dismissed because SFM had a change of position defence. And in other words, both claims would have been dismissed. SFM's claim against the college would have been dismissed by reason of the counter restitution principle, and the college's claim against SFM for the net benefit would have been dismissed by reason of the change of position defence, and the parties would have been left where they were. Now, the learned judge did not apply this approach. The learned judge instead made the following orders. SFM's claim against the college succeeded in an amount of approximately £700,000, representing the value of the use of the building in the period after payments had ceased to be made. The college's claim was dismissed in full by reason of the change of position defence. And in practical terms, what this meant was that the party who received a net benefit under the transaction obtained a further payment in connection therewith, and the party who made the net loss recovered nothing and was required to make a further payment to the other side. And in my respectful submission, that order was wrong in law for essentially 4 reasons, which I will address in due course. The first is that Judge wrongly held that there was no such general principle of the sort that I have sought to describe. And that's the first principal issue on this appeal. Second, the judge erred in law in treating this contract as severable for the purposes of considering the claims and counterclaims each way. Third, the judge wrongly held that there should be no counter restitution in this case because the change of position occurred before receipt of the relevant benefit. And that gives rise to a timing point, which I will address. And the fourth error is that the judge wrongly held that the counter restitution principle should not apply in full because the change of position was not wholly extraneous to the party seeking restitution. And in my respectful submission, each of these points gives rise to a question of law as to the correct test for counter restitution and as to the matters that are relevant for the purposes of deciding whether or not that principle applies on a given set of facts. And in these circumstances, the judgment and the relevant paragraphs on this issue should be set aside, and this court should substitute an order dismissing both claims. That will then in due course have consequences for the cost orders made below. Now, with that introduction, I intend to put my submissions under the following 3 headings. First, I want to look at the key authorities on this question. Now, those authorities often touch on more than one of the relevant issues, but to avoid going to them multiple times, I want to go through them in turn. Second, I will then address each of the 4 errors which I have outlined. And third, explain then how I say this appeal should be resolved. So, subject to my lady and my lords, the first topic was the key authorities. Now, I wanted to start with some general principles relating to the law of unjust enrichment. And it is necessary to begin here in order to put the particular issue with which we are concerned into its proper context. And it is also necessary because, in my respectful submission, some of these submissions from my learned friend are inconsistent with general principles relating to the law of unjust enrichment. And so if I could ask your lordships and my lady to go to the investment trust case, which is in volume 2 of the authorities bundle, behind tab 20. And I will give references to the pagination in the bundle throughout my submissions, if that is okay. This case was concerned with claims against the revenue by certain companies who had wrongly been charged VAT. Now, the companies had not made the payments directly to the revenue. They had paid VAT to certain management companies who had in turn accounted for those sums to the revenue by way of VAT. And the question which arose was whether or not the companies, the investment trust companies who were the claimants, could recover directly from the revenue, even though they hadn't made a direct payment to the revenue. And that gave rise to a question about the proper test for the second of the requirements in unjust enrichment, namely that the enrichment should be at the expense of the claimant. And the Supreme Court answered that question in the negative and held that there was no enrichment at their expense. Now, that is obviously not the central issue on this appeal, but in the course of Lord Reed's judgment, he identified a number of important points about the nature of the law of unjust enrichment, which is what I wanted to look at. And this starts at page 652 in the bundle. And if I could ask my lady and my lords to read from paragraph 38 to paragraph 42. So paragraph 38 starts next to the letter E on page 652. My lords, three important points to note in relation to this passage. The first is that, as Lord Reed says, claims in unjust enrichment do not create a judicial licence to meet the perceived requirements of fairness on a case-by-case basis. legal rights arising from unjust enrichment should be determined by rules of law which are ascertainable and consistently applied. And so this is not an area of the law where recovery is generally granted or denied on the basis of a discretion. Second, and this is the point that is made at paragraph 41, the court should generally separately answer each of the 4 questions that are identified by Lord Steyn. And these are generally the 4 questions that arise in all unjust enrichment claims. If my lady and my lords want to just flick to paragraph 24 on page 648, those 4 questions are set out there. Has the defendant been enriched? Was the enrichment at the claimant's expense? Was the enrichment unjust? And are there any defences? And that structured approach ought to be applied to all unjust enrichment claims.
And you say that means answer those questions in that order, do you?
In general, yes, my lord, I do.
When you say in general, you mean not necessarily?
I say yes, yes, you should. You should apply those in those 4 in that order.
But sorry to press you. In all cases, or might it be appropriate in some cases to answer them in a different order?
Well, it might be appropriate in a case to jump straight to the 4th question where that were a knockout blow. But in general, the structured approach follows in sequence. If there's no enrichment, then there is necessarily no claim. And if there is an enrichment, then the next question is, at whose expense was it conferred? If that answer is negative, then one doesn't get to the next question, which is the enrichment unjust, and so on. Now,
And how do we decide whether it is unjust?
Now, the question of unjustness is not an abstract question. It depends upon establishing that the facts of a particular case fall within what are referred to as unjust factors, my lord. And unjust factors are broadly categories of case where the law recognises a right to restitution. And the right to restitution, examples of those, my lord, would include mistake, failure of consideration, and another one relevant to this case is the right of public bodies to recover funds which have been paid out without statutory authority. And that point is explained by Lord Burrows in the Samsundar case, if your lordship would be assisted by that.
Thank you.
And that is at paragraph 18. 19, my lord, is the paragraph dealing with the unjust.
18.
Paragraph 19, which is
19.
at Authorities, volume 3, tab 23, page 755.
Do you want us to look at it now? So, my lord, in that paragraph, Lord Burrows gives some of the examples which I gave your lordship of circumstances in which it is unjust to retain a benefit.
The third point I was going to make in relation to the investment trust case just concerned the conceptual basis for unjust enrichment claims. And Lord Reed made it clear that when formulating the applicable legal rules in this area, the court should bear in mind the fundamental principle which is underpinning the law, which is to reverse defective transfers of value, or a principle of corrected justice. The object is to restore the parties to their original position. Now, the present case is obviously not concerned with the at the expense of requirement, which is the second question. It is concerned with the correct legal principles governing the requirement to make counter restitution and the relationship between that principle and the defence of change of position. And in my submission, that is also an issue that should not be decided by abstract notions as to what is just on a given set of facts. It is to be decided on the basis of legal principles that are ascertainable and consistently applied. And against that background, the issue with which we are now...
Just pausing for a moment. What Lord Reed says about the Aristotelian basis has to give way, doesn't it, to defences such as change of position?
In certain circumstances, yes, my lord, it does. And that the objective there is that where there's a change of position, it would not be necessary to restore the parties precisely to their original position, because one party would be worse off by reason of having changed its position. That's right.
Thank you.
Now, the counter-restitution issue surfaced most prominently in the swaps cases, which you will have seen from the submissions before you, and it is those that I wanted to go to next. By way of background, as you may know, in the late 80s and early 90s, many local authorities entered into interest rate swaps with various banks and other financial institutions. And in Hazel and Hammersmith, the House of Lords held that such contracts were ultra vires and therefore void, ab initio. And this gave rise to a significant number of cases in which the parties sought to unwind the swaps by bringing claims in restitution. And the first of those cases is the Westdeutsche decision, which is volume 1, tab 7. Now, the facts are complicated because there were two cases before Mr. Justice Hobhouse at the trial. The first was between Westdeutsche and Islington, London Borough Council. And if I may just summarise the transaction in this way. Westdeutsche paid Islington the sum of £2.5 million at the outset of the swap. Thereafter, Westdeutsche and Islington agreed to a swap under which Westdeutsche was the fixed rate payer and Islington was the variable rate payer.
Well, that was part of the swap transaction.
Yes.
But they weren't two separate transactions.
No, it was a single transaction. And Westdeutsche also entered into a back-to-back arrangement with Morgan Grenfell, which was a separate transaction, my lord, under which Morgan Grenfell advanced to Westdeutsche the £2.5 million, and the parties entered into a swap, but the other way around. So Westdeutsche was the floating rate payer and Morgan Grenfell the fixed rate payer. And the decision in Hazel came down before the swap had run its course, so the swap was interrupted before it had come to an end. And that is what is often referred to as an open swap. This was an open swap decision. And if I could ask you to go to page 173. And read from E over the page to H, please. My lady, my lord, the first point to make in relation to this is simply to note that the net benefit was received by Islington under the transaction. And one sees that from the table on page 173. The second point is that, as my lady and my lords will see from the extract, which starts at 173J and goes over the page to B, although each party brought a claim for the total amount which they had paid, Mr. Justice Hobhouse was of the view that it cannot seriously be disputed that on any principle of unjust enrichment, these figures must be netted off against one another, and that the reality of the case is an alleged enrichment of Islington at the expense of West Deutsche in the sum of 1.145 million. And then, just a little further down the page, my lady and my lords will note at F that both parties in the Islington action pleaded defence of change of position. So change of position was in issue in this case in relation to both parties on this swap. The second claim that was before Mr. Justice Hobhouse was the Sandwell.
Just pausing for a moment. Part of the reasoning for taking a net approach was both that the contract provided for netting off and that the parties had in fact netted off throughout their course of dealings.
Yeah, the contract provided for netting off on a 6-monthly basis, but that is only as between the fixed rate payment that was to be made on that day and the floating rate payment that was to be made on that day. And the netting off process that your lordship sees here is a broader one. It's a netting off of all payments going, both all the net payments under the relevant transaction.
But that also was the nature of the swaps contract, because unlike this case, the nature of a swaps contract, or at least swaps contracts of this type, is that there is only ever a benefit which can be identified accruing to one or other party to the contract once it's run its course, i.e. at the final date when it falls to be closed out. And the 6 monthly payments are not only netted off between themselves by reference to fixed and floating rates, but are also netted off by way of final conclusion under the contract.
Yes.
So it is a case in which the contract provides for netting off in the sense we need to look at of all payments, not just the running payments on account, because they are payments on account, as it were. Yeah. The 6 monthly payments are payments on account. Is that a fair way of looking at it?
My lord, it may be, and in a sense that is the defining feature of a swap. The question which arises is whether the principle which emerges in this case applies more generally, and in my submission it does. But it is fair to say that swaps are in the very nature of a case where payments are made both ways.
Well, and in which there is essentially a final accounting.
Yeah, one winner at the end.
Which takes account of all previous payments before you can identify where the benefit conferred under the contract lies.
Yes. Yes. And of course, in this case, the contract was interrupted partway through, and there was still that netting off process.
Thank you.
Well, look, the second claim that one has here is between Climate Benson and Sandwell, and there were 4 swaps between the parties. And it is probably sufficient just to look at the first swap, which one sees on page 175C. And just to look at the, there's the table of payments that were made under this particular swap. And it was Sandwell under this swap that received the net benefit by the end. And your lordships and my lady will note that in this case the swap ran its whole course. So this was a closed swap. And that gave rise to a separate question as to whether that made any difference to the right to recover. And this also gave rise to a limitation question, because the first repayments were made before the 6-year limitation point. And just to note finally that the change of position defence was not in issue on this particular claim. Now, the claims for restitution were put on two distinct juridical bases in these cases. The first was a common law claim for money hadn't received, and the second was an equitable proprietary claim. And his lordship upheld both of those claims. But the second claim eventually went to the House of Lords, and his decision was reversed on that point. So it's only the first claim, the common law claim, with which we are concerned today.
So why did it go to the House of Lords if they won on both?
Because that affected the interest that could be awarded. So Mr. Justice Hobhouse awarded compound interest, and its compound interest was at that stage and now more readily awarded where there was a proprietary claim.
Thank you.
And is it right to say that it's now generally established that claims in unjust enrichment are claims at common law?
Yes, must mention yes. Now, the starting point for our purposes is Mr. Justice Hobhouse's consideration of a series of annuity cases, which had received little attention until this judgment. And the relevant passage starts at page 189. But if I could ask my lady and my lords to read page 190F to 191H, which is the relevant passage. My lady, my lords, in this passage, the learned judge analyses the decisions in the annuity cases and reaches the conclusion that they establish a general principle, and I'm reading here from 191G. Hicks and Hicks also establishes the general principle that restitution must be mutual, and that the nature of remedy is a form of mutual restitutio in integrum. That is to say, putting the parties back into their original positions. And this is an earlier example of the same principle as that applied in Newbigin and Adam in relation to the law of rescission. where Lord Justice Bowen stressed that there ought to be a giving back and taking back on both sides. And so this is what Mr. Justice Hobhouse is identifying here is described in terms as a general principle, not as a principle that is confined, for example, to a swap case, in response to my Lord's question.
Lord Ellenborough in Hicks and Hicks, you can see from the passage at C, put the netting off on the basis of a mutual set-off of claim and cross-claim.
Well, it's described as a mutual set-off in that passage, and it will be seen that that's not how Justice Hobhouse saw it in the balance of the judgment, and he's right in that respect, in my submission. And then if I could ask my lady and my lords to go on to page 197, and this is where his lordship applies the principles to this case. And if I could ask you please to read at page 197 under the letter F. Down to over the page to G.
So recognising, as it were, the melding of the approach both in common law and equity, and specifically recognising the concept of quantum merit.
Yes, yes. And that is an important point, because one of the points made against me by my learned friend is that the position ought to be different depending on the type of benefit that has been conferred under the contract. So whereas in Westdeutsche one was concerned with the payment of money both ways, in the present case one is concerned with the payment of money on the one hand and the use of the building on the other. But in my respectful submission, that can make no principled difference. In both cases, there has been a benefit going both ways. The legal principles are precisely the same. And as my lady points out, in this paragraph, Mr. Justice Hobhouse expressly acknowledges that as part of the process of counter restitution, there may need to be a quantum merit payment or a quantum, I hesitate to try and pronounce it, valet-bat. And indeed, it would be surprising if the outcome were different simply because of the nature of the benefit, because that would result in very different outcomes on very similar facts. Now, of course, where the benefit involves the non-payment of money, there can be complicated questions of valuation of the benefit, because it's not simply the payment of money, it involves identifying the value of the use of property. But in this case, that question was resolved by the judge, and it's not on appeal. Once the value benefit has been ascertained, then the netting off process applies in exactly the same way. Now, the other point I wanted to just emphasise was in that same passage, which is at page 197, F to H. It's the passage which says, accordingly, the remedy is only available, I'm reading from G, the remedy is only available to a party on the basis that he gives credit for any benefit which he has received. He must give credit for any payments which have been made by the opposite party to him, and where the court thinks appropriate, pay a quantum meruit or a quantum valuet. The same conclusion follows from the application of the principle of unjust enrichment. Insofar as the recipient has made cross payments to the payer, the recipient has ceased to be enriched.
So the second of those reasons treats it as an exercise which is conducted at stage 1 of Lord Steyne's first stages.
Yes, my lord.
Enrichment, rather than stage 2, taking account of what is or isn't unjust, although there's a hint at least of the second of those in relation to change of position defences when you get to 198B, when he talks about defences which affect the equity, which one might think were defences. So that if one were trying to take our 4 ingredients and see whether you have to apply them in a single linear order, one already sees here the overlap between the different areas. Change of position defences may go to what is just. Net benefits may go to whether there's an enrichment or whether there's an injustice in the enrichment.
My lord, there is intense academic debate, as you may have seen from the authorities in Volume 3, as to which of the 4 questions counter restitution affects.
Yes.
And there is actually a similar debate in relation to change of position as to whether it affects the enrichment stage because the defendant has ceased to be enriched, or whether it's a question affecting the justice of the case overall. The same debate arises in relation to counter restitution. So it is, in my submission, clear that in this passage, Mr. Justice Hobhouse treats that as affecting the first question, whether there has been an enrichment, because one sees that insofar as the recipient has made cross payments, the recipient has ceased to be enriched. That is said in terms. But there are academics who say that it ought to be a defence which arises pragmatically in order to marshal 2 claims in opposite directions. Now, in my respectful submission, actually that academic debate is unlikely to be one which your lordships necessarily need to resolve on this appeal, because whatever stage of the analysis one treats this defence, it is still necessary to decide in what order the defences of counter restitution and change of position apply, and that must be a decision which is made for principled reasons. And as I said in my skeleton, pointed out, even Professor Burrows, who takes the more pragmatic view, would still say that counter restitution ought to apply before change of position for principled reasons. So it is a difficult and complex academic debate as to which stage of the analysis the defence comes in. In my submission, it's not one that you need to be resolving on this appeal. But if you were minded to do so, it is in my submission clear that it affects the first question, and that is what Mr. Justice Hobhouse said. And that obviously more readily leads to the conclusion that it applies before the change of position defence, because insofar as the 2 enrichments are netted off against one another, there is only ever one claim to consider. It's the claim to the net benefit. And change of position can only ever apply to that claim.
And do you say anything turns on the fact that in this case it's all money, going one way or another, depending on whether the exchange rate is going up and whether your gamble is good or not? Whereas here we've got money being paid for use one way and use the other.
No, I say that makes no difference on analysis, and we will come to look at the nature of this contract in due course. But it isn't. Short answer to your lordship's question is no. It makes no difference. The principles apply equally. But I do also say that this isn't the substance of this contract is not a simple operating lease involving the payment by the college for the use of the building. That is not a proper characterisation of the payments that were made in this case.
Would your submission be the same if that were the characterisation? One's looking at the connection between the payments and the benefit as the two benefits which one's considering getting off.
Yes, my submission would be it's the same.
So in a pure hire case in which payments were being made for the benefit of the hire periodically, let's say annual payments in advance for the use of a chattel, where because of the nature that a bargain that had been made, the payments were in fact greater than the value of the use of the chattel. Even in those circumstances, you say you net off the whole of the payments that have been made against the whole of the use. You don't look at the payments by reference to the use which has been paid for by those payments.
That's right, my lord. In a circumstance where the transaction is void from the outset, assuming that's the case. Yes. But the point I was seeking to make is that in one sense that's one stage removed.
I understand you say that's not this contract. I understand.
Can I then ask your lordships and my lady to look at how the question of limitation was dealt with, which is at 208H. And if I might just summarise the argument, in this situation, the first three payments...
I'm so sorry, I missed the reference I was making.
No,
Could I have it again?
I'm very sorry. It's 208H.
Thank you.
And it runs to 210B.
Do you want us to read all of that now?
Yes, my lady, yes. Lady, my lords, there are two main points just to note here. The first is that you clearly see the netting off principle being applied again in this context. And Mr. Justice Hobhouse says in terms that the claim is only ever for the net sum. And since payments had been made within the limitation period in excess of that amount, no question of limitation arose. The second point to note,
And that's clearly here on the basis, as one sees just above B and just above E, that it's enrichment.
yes,
The counter benefit
absolutely,
prevents the enrichment, or
Yes.
reduces the enrichment.
that's exactly right.
Yes.
And then the second point I wanted to make is that there's clearly an emphasis here on there being a single transaction between the parties. And my lady and my lords will see that from on page 209D, there's a reference to there being only one underlying transaction involved. And then at 209H, where there have been a whole succession of payments one way and the other in respect of a single underlying transaction, both equity and justice require that one should have regard to the totality of those payments and the resultant overall benefit and detriment, and not have regard to some arbitrary cut-off point.
Sorry.
No, please, you go.
How far do you take that? Do you suggest that that's a principle that applies to any kind of payment under a single underlying transaction and any kind of underlying transaction, or is there a limit on that general principle, which depends upon looking at the particular nature of the payments and the particular nature of the transaction?
So, in my respectful submission, there is a general principle and so that's the starting point in a case like this, is that where there has been a mutual exchange pursuant to a transaction, and there are claims both ways, then the general principle applies. Now, there are certain exceptions to that, and those are addressed in the commentary, but neither applies. So there is a suggestion that where one party simply has no right to recover the counter benefit at all, then there's no need to provide counter restitution. And there may also be policy reasons why counter restitution can't be provided, for example, in public authority cases where to do so would be inconsistent with the rule which rendered the transaction void. So I don't go so far as to say there could never be an exception to that principle. But what I do say is that the general principle plainly applies in this case.
Well, one of the exceptions you formulated was where one party has no right to recover the counter benefit.
Yes.
Would that be so if the other party had a change of position defence?
No, and one sees that from West Deutscher itself. The relationship between a change of position is not a reason for refusing to provide counter restitution.
Well, I'm not quite understanding what the nature of the exception is that you're identifying, where one party has no right to recover the counter benefit.
So that is in the commentary most often referred to in the context of the Guinness case, where certain directors sought a quantum merit in respect of their payments, their services that they had provided, and that was refused because they hadn't been properly granted the right to payment, and so it would be inconsistent with that rule to do so. I can provide your lordships in due course with the reference to where that's discussed in Professor Boris's.
Yes, no, I've seen it. It's not an entirely easy case to reconcile.
No, it's a very difficult case.
With other principles.
Yes, it's a very difficult case, that one. But that was the exception that I had in mind when I was referring to it, my lord.
And just for the sake of clarity, in respect of the passage you've been referring us to, and in respect of the facts of this case, are you saying that there is one single underlying transaction?
In the present case, absolutely.
I'm sure you'll come to it later
I will.
on, but I just want to get that clear now.
That's absolutely right, I do.
And can I just ask one question on your netting off? You've given us the figures between the two parties, which I understand. Does the netting off and the value of the benefit exclude what is paid to others? I mean, we know, for example, that the respondent had to make payments to get hold of the building.
My lord, yes, it does. So the netting off process refers to the payments made each way under the relevant transaction. The payments that were made by SFM to acquire the building are only relevant to the extent that there's a change of position defence. They're not relevant for the purposes of counter restitution.
Thank you.
Unless what is being suggested is that for some reason that renders counter restitution impossible and so gives rise to a defence. Now, there is a hint of that in my learned friend's skeleton, but it's difficult to see where that would get my learned friend, because if counter restitution is impossible in this case, then the claims should be dismissed. That's the ordinary rule, and that is the very order that I seek on this appeal. So the last part of this judgment, and with apologies for having taken so long to go through it, it concerns the change of position defence, since that is obviously of central relevance for our purposes. And it starts at 216. If I could ask you to please read 216, just F to H, please.
Yes.
And my lady and my lords will recall that Westdeutsche had pleaded a change of position defence in response to Islington's counterclaim. And the judge holds here clearly that that is simply irrelevant, because there is only ever one claim for the net benefit, and that's a claim by Westdeutsche against Islington. So the only party who can raise a defence of change of position is Islington. And Westdeutsche's allegation of such a defence has no relevance. Someone sees that at 216H. And so, in my respectful submission, the relationship between counter restitution and change of position was squarely one of the issues before Mr. Justice Hobhouse in this decision, and he held the netting off process reduced the claim to a single claim for the net benefit, and that in those circumstances the change of position defence only became relevant to the extent of the claim for the net benefit. And just three further observations on this passage, if I may. The first is there's no suggestion here that this is a discretionary matter. This is a decision of principle. And the second is there's no suggestion that this somehow depended on the order in which the change of position and the benefit occurred, the timing point that I referred to earlier. And the third is the straightforward point that there's no investigation here as to the extent to which Islington might be responsible for the change of position, or might have known about it, or might have been involved in it. So, my lord, that is Westdeutsche, my lords and my lady, that is Westdeutsche at first instance, and the following propositions emerge in my submission from the judgment. The first is that there is a general principle that one party cannot recover payments made pursuant to a void contract without first giving counter restitution of the benefits which is received in return. The second is that that is a general principle, as that is what it was described as. It's not a discretionary matter. And the third is that this principle is not concerned with any form of counterclaim. It is a qualification on a party's right to recover and goes to the first of the unjust enrichment questions, the enrichment question. And the fourth is that principle applies.
Sorry, I'm just let me get that.
Yes,
You're on your third now. The principle is not related to the counterclaim, it's the qualification, yeah?
On each party's right to recovery.
Yeah.
So it affects the first question, the enrichment.
The enrichment question.
And the fourth was that this principle was applied before any consideration of other defences, such as change of position or limitation. Now, I want briefly, if I may, to just show you how the case was dealt with on appeal, because it went on appeal. Now,
Just before you do that, will you forgive me for just asking something. It may be that this is something you'd want to come back to in relation to the change of position defence, but the approach of Mr. Justice Hobhouse to netting off, you've suggested, was essentially to treat it as something that goes to the first of the four stages, whether there has been an enrichment.
Yes.
And when he comes to change of position at 216H, he also identifies that as the reason the change of position, or one of the reasons the change of position doesn't apply there. Simply, there has been no enrichment.
Yes.
And you mentioned earlier that there are differences of view in relation to change of position as to whether it's a question of enrichment,
yes,
as I think Lord Templeman treated it in Lipkin-Gorman, or whether it's a question of injustice. But if one sticks for the moment with the approach of Mr. Justice Hobhouse and what one gets out of his decision, he was treating enrichment as the relevant criterion, both for netting off and for change of position. So on his approach, because he held there was no enrichment, it didn't matter in which order you took them. So does one get very much out of this in terms of your submission, that the order in which it's to be done is, first of all, netting off, and secondly, any defences including change of position? If enrichment is the criteria for both of them, there isn't necessarily a right order for either of them, is there?
My Lord, 2 points in response to that. The first is that if the two claims had been looked at entirely independently, so one had looked on the one hand at Islington's claim against Westdeutsche for recovery of the money, and on the other at the claim going the other way, then in principle there would be two enrichments to look at, and change of position could well be relevant to both claims in principle. And so one may well end up having to investigate the change of position defence for the purposes of each of those claims on each side. Now, Mr. Justice Hobhouse did not look at things that way. He applied the netting off approach, reducing them to a single claim for the benefit received. And so in my respectful submission, actually it does tell you which order the two issues were looked at. And it does show that the netting off principle must have been applied first. Otherwise, it would have been necessary to investigate whether Westdeutsche had a complete answer to Islington's counterclaim such that there ought to be no netting off at all. The second point I wanted to make was that actually looking at both defences as going to the question of enrichment is, in my submission, helpful for my case, because one is concerned always with change of position. So change of position is concerned with matters which give rise to a disenrichment, or which make the defendant worse off. So looking at things in enrichment terms, there is initial enrichment to the defendant in the receipt of the benefit. Change of position then asks, is the defendant worse off for some other reason connected with the transaction? For example, because the money has been given away to someone else, or because they've entered into a transaction. But one must first identify what the enrichment is before one can then ask whether there has been a disenrichment of some sort. And the netting off principle goes to the first question: what is the extent of the enrichment received? And it's only then that one asks, is there a change of position? And that is how I say that things ought to be approached on this appeal.
I understand that. And I think one must be careful in this area of the law not to try and articulate principles that may apply for every possible factual
Indeed.
variation. But if one looks at change of position as something which looks at benefit, then it may be the case that there's initial benefit and then a reduction of the benefit by the change of position.
Yes.
But in cases of anticipatory change of position, it may be that the analysis is that at the moment of receipt there isn't in fact a benefit. If a party has incurred an expenditure at the request of the provider of the benefit, which is then going to be reimbursed, as it were, by the conferring of the benefit, it may well be that the conferring of the benefit doesn't in fact confer an enrichment. It merely goes to defray the anticipatory change of position. Some cases of change of position, if we're looking at them in terms of benefit, may be benefit received and then, or enrichment received and then disenrichment or enrichment defrayed. Some of them might be no enrichment in the first place because there's been an anticipatory change of position. Is that a fair analysis?
My lord, it's entirely right to look at it, that there can be an anticipatory change of position. I clearly don't disagree with that. What I do say is that it would be odd if the application of the counter-restitution principle ought to depend on the order in which the disenrichment and the enrichment occur. And it's well established that that isn't the law for the purposes of the change of position defence, and that an anticipatory change of position can result in a relevant change of position for the purposes of the law of unjust enrichment. And in my submission, it would be odd then if the application of the netting off process somehow depended upon that distinction. And I submit that wouldn't be the right answer. The right answer in these cases is to look first at the benefit which was conferred on each party pursuant to the transaction, to net that off, and then to ask whether there's a change of position in relation to the net benefit. And that may be an anticipatory change of position, but it may also be a change of position which occurs afterwards.
But it may matter to your analysis because netting off assumes that there is a benefit to be netted off. If at the moment the benefit is received, it's not an enrichment at all, there's nothing to be netted off. I quite understand that if the change of position is receipt of benefit, subsequent change of position, you can say, well, there's been a benefit at that stage, therefore you say take that benefit, net it off, then go on to consider a change of position. But if the analysis of an anticipatory change of position in a particular case is to prevent the benefit arising in the first place, there's nothing to net off, is there?
Yes, but in my respectful submission, that is not the proper analysis of the change of position defence. It doesn't prevent there being any form of benefit at all. There is still an enrichment in those cases. It's just that the party has suffered a corresponding detriment, and one looks at it overall at the end. And that's the proper analysis on those cases. So there's no suggestion in the present case, in the learned judge's judgment, that there was no enrichment that occurred, because plainly one side got money and the other got the use of the building. The change of position defence is then concerned with the defendant's global position, overall position, not the position as a result of the particular transaction. And
It's a netting off of the defendant's position. But you say that netting off, one must be careful, not all change of position defences will fall into this category, but where it involves a disenrichment, then it involves a netting off, either because there's a receipt and then there's a subsequent disenrichment which nets off, or possibly in some cases of anticipatory because there's an immediate netting off at the moment of receipt. So that's questionable whether there's been a benefit at all. But your argument essentially, as I understand it, is that netting off, which occurs for the change of position defence, always has to happen second.
Generally has to happen second after the enrichments going both ways have been netted off against one another.
But in terms of justice, what is unjust or not about the enrichment? Why should the one take place prior to the other?
Like, one way or another, there has to be an answer to that question, in my respectful submission, because the two principles point in opposite directions. So the counter restitution principle requires one party to give back what it has received in return as a condition of bringing the claim in unjust enrichment. But change of position identifies certain circumstances in which one party doesn't have to give back what it has received. So those two principles cannot stand with one another, and a decision has to be made as to which one is applied first. And the reasons that I gave in my skeleton are policy reasons for why, and analytical reasons for why one would approach things in the order for which I contend.
But surely underlining it has to be the concept of what is just.
Yes, indeed, my lady. At the global level, that is always the central question.
And therefore, in considering what is just, it requires an adjustment of what is considered first.
Indeed. But one could only do that by formulating an exception to a general principle. So that this area of the law has principles which regulate the order in which these issues arise. So the question then would be, is there some exception to the general principle which ought to apply on the facts of this case and to similar cases? And in my submission there isn't such a reason, for reasons that I will come on to.
Yes.
My lady, my lords, I was going to look at the Court of Appeal next in Westdeutsche just to understand what happened. Now, Islington's argument was that there was no right to restitution. The only point which went on appeal in this case was the Islington action. The Sand Oil action didn't go any further. And so this was the open swap situation. And the only point that was made in this case was that where there's been partial performance of the swap, there could be no right to restitution. And that was rejected by the Court of Appeal. And there's just a few passages I wanted to show my lord and my lady. Starting at page 228H. If I could ask you please to read 228H to 229F.
Whose judgment is this?
This is the judgment of Lord Justice Dingemans.
Thank you.
The only reason I show you this, my lady and my lords, is that my learned friends place some reliance on this passage as supporting an approach of severance similar to the approach which the judge adopted. And in my respectful submission, that is not correct. What this passage is looking at is an argument that there has been a failure of consideration in relation to the net benefit that's not been returned. So the severance question here concerns whether there's been a failure of consideration. That is the third question in the four unjust enrichment questions.
Is that right? Is this not addressing an argument that the whole claim has failed because there's been only a partial failure of consideration, not a total failure of consideration? Yes. To which one of the answers is you can you can sever parts of the contract and look at whether there's been a total failure of consideration in relation to the part that is relevant. Yes,
that is right. And what one sees is what is the severance being applied to, and at 229D. Lord Justice Dillon says the effect of severance is that there has been a total failure of consideration in respect of the balance of the money which has not come back. So that's the net benefit he's referring to there. And just to foreshadow what I will say in due course, this consideration of this analysis of a total failure in relation to a part of the consideration simply doesn't arise in our case at all. And it doesn't arise in any case where most cases where the transaction is void from the outset, because in such cases the enrichment will be unjust for other reasons. And that is a point which is made in due course in the Guinness-Marn case, which I will come to. And just for my lady and my lord's note, we don't need to go to it now, at 229F to 230F, Lord Justice Dillon also analyses the annuity cases, which I showed you, and agrees with Mr. Justice Hobhouse's analysis of that. And then finally at 230 F to G, and just to show you this passage, which is also relied on by my learned friends, the only point being made here by Lord Justice Dillon is that it doesn't need to consider whether the principles should be different or the same, where the payment was not something involving the payment of money. Now, I think my learned friends say this shows that the position could well be different, quoting their skeleton, but I don't think in my submission it doesn't go that far. It simply says that he's not expressing an opinion one way or the other. But I have already explained why the nature of the benefit shouldn't make any difference to the application of the counter-restitution principle. And then, can I ask you then to look at Lord Justice Leggett's judgment at 967 and H to J.
Well, isn't it in that final sentence, to achieve that where there have been mutual payments, the recipient of the larger payment?
Indeed, my lady, and that in my respectful submission is endorsing the netting off process. And obviously the reference to there being mutual payments is because that is what happened in this case. Payments had gone both ways.
Well, for a period, but then that changed, didn't it? And it became
Yes, it became a one-way
It did.
at one stage.
That's right. Yeah.
But the payments as a whole were all netted off against one another. And then could I ask you to read page 237 C to D, which summarises Lord Justice Leggett's conclusions. And again, one sees in this passage, the point being made is that where the contract is void from the outset, then the enrichment is unjust for the simple reason that neither party got a legal right to counter performance. And the appropriate order in those circumstances is that insofar as the payments made by insofar as the payments exceed the payments made by Islington, they can be recoverable as money had and received to the use of Westdeutsche. So again, one sees a netting off process being applied. And for completeness, Lord Justice Kennedy at 239G agrees with both judgments. And so, standing back, the Court of Appeal here endorses Mr. Justice Hobhouse's finding that there was a right to restitution. And one sees that being endorsed in terms which refer to there being a claim for the net benefit under these contracts. And one also sees Mr. Justice Hobhouse's analysis of the annuity contracts being confirmed. My Lords, my Lady, the next case, it may not be necessary to turn it up, but in this run of cases, then there was also a further set of litigation between Kleinbach Benson and South Tyneside Metropolitan Borough Council, which is at tab 8 in the same bundle. And 2 points, if I may summarise what happened in this case. 2 points are relevant. The first is a limitation argument. And the second was an argument that counter restitution was impossible. And in relation to the limitation issue, the facts were slightly different to how they had been in the Westdeutsche decision, because the payments made during the limitation period were less than the net benefit received overall from the transaction. And Mr. Justice Hobhouse held that in those circumstances, the claim was limited to the lower amount of the payments made during the limitation period. And in my respectful submission, that is nothing more than an application of the reasoning in his first judgment. One starts by netting off the benefits, and then one applies the limitation defence. And what that meant in this case was the benefits were netted off against one another, but limitation cut down the claim.
Well, or you could do it in the opposite order and say that the benefits that are time barred don't fall to be taken into account as benefits at all. So that at stage one you don't. It doesn't really help us very much, does it, on what order you apply the principle?
Yeah, but it is relied on by my learned friend as illustrating an exception. That a different approach was taken by Mr. Justice Hobhouse in this particular case compared with the Westdeutsche case. The point I make is there is no difference in the two cases.
Because the netting off always appeared first,
Yeah.
and then limitation wasn't relevant in one and it was in the other.
Indeed,
Yeah.
yes, my lord. Now, it may be relevant to note that one of the answers that was given to the limitation point was a suggestion that there were 5 swaps in this case, and that the 5 swaps should be looked at globally together. And the learned judge rejected that. submission and held that each swap needed to be looked at individually because they were single separate transactions. I don't propose to turn it up, but it's for your lordships and my lady's note. It's page 247 H to J.
Is it worth looking at the basis on which that situation was distinguished from the single transaction, which looks at 979J as though it was on the basis that there wouldn't have been a right of set-off between the payments? So it's a cross-claims basis, as it were, or possibly an unjust, if that's the same test for set-off.
Yeah, the passages at the bundle references 247J, and two separate points are made in that paragraph. It's each interest rate swap was an independent transaction, and there was indeed no right of set-off or aggregation between the two. So yes, the terms of the contract were relevant too, and I don't shy away from that.
In a case in which there were a right of set-off between two separate transactions, would they then be treated as netting off?
Well, that might depend on whether you could, in those circumstances, characterise them as a single transaction. And there are established principles for answering that question in the law of rescission, which I've referred to in my supplemental skeleton. So I don't think the mere fact that there was a set-off or clause between two separate transactions would automatically give you your lordship the answer to that question.
Does that mean that in a case in which, if they were brought as cross-claims, the court would apply the principles of equitable set-off and unconscionability, net them off, it won't necessarily do so for the purposes of counter-restitution?
Where the claims are made in unjust enrichment relating to a single transaction, that's right.
No, if you have separate transactions,
yes.
I think you're suggesting that whether you net off is not dependent upon a right of set-off, and you may have cases in which you didn't have a right of set-off, but you would net off, or vice versa.
Yes.
What I'm putting to you is that seems slightly odd when the touchstone for equitable set-off is unconscionability, and the touchstone for the unjust element of unjust enrichment is injustice or unconscionability.
Well, my lord, there are a couple of points to make in relation to that. And the touchstone for equitable set-off certainly takes into account considerations of equity, but it is still a principled. One still has to approach cases on a principled basis, even in that context. But in any event, equitable set-off is concerned with two separate claims, distinct claims being brought together for procedural reasons. And so it is a conceptually distinct defence from the counter-restitution defence. The counter-restitution defence, as your lordship has noted, it is concerned potentially with the enrichment stage of the analysis.
Well, I'm just exploring whether that is so.
Yes, yes.
I mean, speaking entirely for myself, I can see that conceptually counter-restitution may apply to reduce or extinguish a benefit and therefore come in at the enrichment stage. It may apply to make it not unjust for the enrichment to stay where it is, or it may apply because there are cross-claims in circumstances where they would be set off. So I don't start with an a priori assumption that one of those is the right analysis. What the reason I'm asking these questions is that I'm interested to try and identify whether they are all available or whether only some are available to answer the question.
Yes, and in my respectful submission, The right answer, which one gets from Mr. Justice Hobhouse's decision, is it affects the first question. Now, an alternative analysis may be that it is more similar to an equitable set-off, and that is the analysis which one sees from Professor Burrows in Volume 3. But even then, one still has to decide whether that principle applies before or after a change of position. And in relation to the unjust stage of the analysis, my lord, your lordship said that the touchstone for that is unconscionability. But to reiterate that what that means in this context is that one has to establish one of a series of categories of unjust factor, not simply ask in the abstract whether it would be unjust to retain the benefit. The question is, was there a mistake? Was there a failure of basis? Or was there some other recognised reason for restitution?
Oh, I hadn't appreciated that was what you were citing Lord Burrows' case for.
Yes.
Sam sued her. I understand that we don't have a unified law of restitution, at least so far, and we haven't gone in the direction of travel that Professor Burks would have wanted.
Yes.
And I think, at least in this court, it's not open to us to adopt it. We have categories of cases, and the categories of cases that Lord Burrows were identifying are those categories of cases that one has to
Indeed.
come within. One might conceptually say, well, that's the stage before you address the four stain principles. You've got to come within your category of case, and then you look at is there enrichment, etc., etc., etc. And Lord Burrows, in the passage you showed us, seemed to be saying, actually, that's an aspect of unjust, the
Yes.
third element.
Indeed.
But was he saying that categorization is the only element of unjust that applies at stage 3? That one's not looking at injustice more generally at stage 3?
In my respect, yes, that's entirely right. There are reasons for restitution which tell you when it is unjust for a party to retain the benefit. And a claimant bringing a claim in unjust enrichment has to fall within one of those recognised categories, unless the law recognises another category, which, as with all incremental development in the common law, is...
That I understand, but I understood your submission a moment ago. I may have misunderstood it to be that injustice under the third heading is solely a question of whether it falls within one of the categories. Is that your submission?
Yes.
Can you just give me the page reference again to the quote from Lord Burrows, please?
Yes, indeed. It was in... it is in Authorities Bundle 3.
755.
Thanks very much.
02. my lords, the only other point which arises out of the South Tyneside case is that there, in relation to one of the swaps, there was no restitution on either side because counter restitution was impossible, and that was because there were in fact three parties to the transaction at different points in time. Now, my learned friends refer to that, but as I said earlier, it's unclear where that would get my learned friends, because if counter restitution were truly impossible in this case, because of some contract between his client and a third party, then there would be no claim either way, and the claims would fail. So there would be a complete defence. And so that's all I wanted to say on that.
And the judge addressed who were the proper parties from paragraph 403 of the judgment, and there's no appeal against any of that.
No, there isn't. The final swaps case is the Guinness-Marn case, which is behind tab 10. And this was an appeal in relation to a closed swap. So in a sense, this was the Court of Appeal reviewing the other aspect of Mr. Justice Hobhouse's decision that did not go any further, albeit it was obviously a separate case. And I should say that by this stage, the House of Lords had handed down its judgment in the Westdeutsche decision and had overturned Mr. Justice Hobhouse's judgment on the proprietary claim. But the House of Lords did not cast any doubt on Mr. Justice Hobhouse's analysis of the personal claim in passages that we will see. Can I start with the judgment of Lord Justice Morritt? At page 287 of the bundle. And I could ask you, please, to read 287D to 288B. And so, my lady, my lords, that is just to make good the point that the House of Lords, in passing, did approve of Mr. Justice Hobhouse's approach. And one sees in the passage at 287F from Lord Gough's judgment that what happened was the ascertaining balance on the account between the parties and ordering repayment of balance. And Lord Gough considered that to be self-evidently right. my lords, my lady, then one sees Lord Justice Morritt's own reasoning at page 291 C to E, which explains the reason why there is a right to restitution even in a closed swap. My lady, my lord, that's an important point in the present case, because the same reasoning applies. In this case, what the parties bargained for was a contractual right to performance from each other, and there was no such right. The contract was void. And so on that basis, there was a failure of basis from the outset, or a failure of consideration from the outset of the transaction. And that is why it makes no difference whether it's an open or a closed swap. It's unjust in both cases for the person holding the net benefit to retain it. Lord Justice Morritt then goes on to deal with severance, and I said I would come to this earlier in my submissions, and that starts at E and goes over the page to A. If I could ask my lady and my lords to read that passage too.
Sorry, could you give me the reference again?
Yeah, it's page 291E to 292A.
Thank you. My lady, my lords, in this passage, what Lord Justice Morritt is saying is that where a contract like this is void from the outset, the question of severance simply doesn't arise when considering whether the enrichment is unjust. And that is because neither party got the benefit of a contractual obligation at all. And so the enrichment was unjust from the beginning. And my lady, my lords, the next point, just to finish Lord Justice Morritt's judgment, at 294B to E, that there's a summary. And the critical point is between C and D.
And the proposition stated at 3 is clear. A party to an apparent swap contract which is void, because ultravire is one party, is entitled so to recover the amount by which what he paid exceeds what he received, whether or not the apparent contract has been completely performed, for there is a total failure of consideration, whether it is regarded as entire or severable. Then, just one sees, Lord Justice Waller gave a concurring judgment at page 294 F. One sees he agrees essentially for the reasons given by Lord Justice Morritt. In the balanced judgment I wasn't going to go to, he addresses the question whether it will always be unjust in a void contract, whether there will always be an unjust factor in a void contract, but not the question of severance, which is what I wanted to look at. The final judgment is Lord Justice Robert Walker, and again at 298 B, he agreed that the appeal should be dismissed very largely for the reasons set out in the judgment of Lord Justice Morritt. And just to look at his treatment of the question of severance, it's at page 299H to 300A. And so just pausing there, 2 points emerge from the Guinness-Marn case. The first is that Mr. Justice Hobhouse's analysis of a closed swap was upheld, and there is a right to restitution of the net benefit, even in a closed swap. And the second, as one sees from Lord Justice Morritt and from Lord Justice Robert Walker, is that the notion of severance isn't helpful or relevant in that context.
But this authority also established that there was no difference between an open or closed swap. There was just a total failure of consideration.
Indeed.
Notionally, this contract would be open because the contract hadn't run its course.
It would be, yeah.
But it makes no odds according to your submission. Is that right?
That's right. Yeah, that's right.
But the point being made by Lord Justice Robert Walker and reflected earlier in what Lord Brown Wilkinson said in the House of Lords in West Deutsche has echoes of what I was putting to you earlier about the nature of a swap contract. You may be in the money or out of the money as you go along, but essentially severability is just a completely inapposite concept to the mutual obligations of 6 monthly or whatever it may be, periodic accounting to a swap. Known constat that severability is a concept which is not of use in some other kinds of contract, which may be severable, and where severance may give you an answer as to whether one nets off.
Yeah.
So that I'm not quite sure how much you get out of this. I understood you to be citing it to us, essentially for the proposition that severability isn't a relevant concept in the context of netting off. Speaking entirely for myself, all I get out of it is it's not a relevant concept in terms of whether there's total or partial failure of consideration.
Quite.
And in relation to swap contracts themselves, it's not a relevant concept in relation to those kinds of contract.
Quite, and I wouldn't want to overstate it. Those two propositions are as far as this case goes, and I will have to come to whether or not this particular contract, severance, is useful in the context of this particular contract in due course. But it serves simply to note that it's not relevant in that context of the swap transaction, and that may be partly due to the nature of the transaction, but also because the consideration failed from the outset.
All right, Mr. Watkins, so where do you want to take us now?
So I could be very brief as to the remaining authorities I wanted to look at, but there are two further authorities which do not concern swaps cases, but in which one sees the principle of netting off being applied, or at least approved. And the first is the Goss and Chilcott decision, which is in volume 1, tab 9. And this is the decision of the Privy Council. And in summary, what happened was that the claimant had advanced money to Mr. and Mrs. Goss on terms which required them to pay interest and to grant a charge over their home. And Mr. and Mrs. Goss had agreed that the funds could then be paid on to a third party, a solicitor called a Mr. Haddon, who had assured them that he would make sure that the loan was repaid. He then altered the terms of the mortgage deed without the mortgagor's consent, and that meant that the mortgage was discharged from the point of alteration. So not from the outset, but from when the mortgage deed was altered. 2 interest payments were made to the claimant, but thereafter nothing more. And Mr. and Mrs. Goss argued on appeal that they didn't need to pay back any part of the advance, the £30,000, because there had not been a total failure of consideration. And that was because they had made 2 interest payments. Now that was a difficult argument to make in the circumstances, and the Privy Council unanimously rejected it. And if I could ask my lady and my lords to look at page 275E. Down to 276 E. My lady and my lord, so just 2 points to note in relation to this. The first is the discussion of severance is taking place in relation to the question whether there's been a failure of consideration, which my Lord Justice Popplewell referred to earlier. That is the sense in which it is being used here. And as Lord Justice Morit explained in Guinness Marn, that is not an issue that arises where the contract is void from the outset, because there are other reasons why the enrichment is unjust. So the discussion of severance here is not in the context of counter-restitution at all. The second point is that insofar as this does touch on counter-restitution, there is a clear approval of the order that was made in Westdeutsche itself, and one sees that at 276, between 276D and E, and that's a reference to the a decision of the Court of Appeal. Then the final case was a decision of the Singapore Court of Appeal in the Skandinaviska case. I'm not sure that it's necessary to turn it up. It may be sufficient for me to explain what happened. It's in the authorities bundle, just for your note, at volume 2, tab 16. And obviously this isn't binding on your lordships and my lady at all, but it is another example of the principle in Westdeutsche of counter restitution being applied outside the context of a swap transaction. And what happened was a fraudster called Mr. Leng, who's referred to as Chia in the report, obtained money from the claimant by pretending that he had authority to enter into loans on behalf of his employer, the Asia Pacific Breweries. And in order to cover up his fraud, he also procured the making of payments by Asia Pacific going the other way, so that it looked like the loans were being repaid, and he had no authority to do that. So when the fraud was discovered, SEB, the claimant, sought restitution of the monies that they had advanced under the loans. And a question arose as to whether or not the payments should be netted off against one another, leaving a claim to the balance. And the judge below had held that they should not, and the Court of Appeal overturned that decision. And the relevant part, just for your note, is at page 471. And in that context, they reasoned by analogy with the swaps cases to which I've referred, and based their judgment on Professor Birks's work. You will also note from that decision that there was an issue about change of position, but that was considered after the court had resolved the question as to whether enrichment fell to be determined using the netting off approach. In the event the change of position defence failed anyway, so that's that. And so those were the authorities I wanted to refer to. Now, those cases have been addressed at length in the academic literature, and unless it would be of assistance to my lady and my lords, I wasn't proposing to go through that. It may be sufficient for me to summarise the position as best I can in the academic literature. Now, one sees in that material, most of which is in volume 3 of the authorities bundle, two schools of thought as to what the counter restitution principle is doing. The first school of thought is that it concerns the enrichment question. And so it is a rule that the benefits going both ways are netted off against one another in order to identify a single claim to the balance. And then that rule is justified by the fact that where benefits are conferred as part of a process of mutual exchange, that same element of mutuality has to be applied in order to determine the claims to restitution. The second school of thought is the
You say it's a rule, you mean it's a principle which falls to be applied if and because it affects the extent of the enrichment?
Yes. There is a mutual process of exchange, yes. Now, the second school of thought is that counter restitution operates similarly to a set-off defence. And it's a pragmatic rule that ties the two claims together because there is inevitably a very close connection between the two claims. Now, Professor Birks and Goff and Jones consider that in the swaps cases, and in particular in the Westdeutsche case, Mr. Justice Hobhouse followed the first approach, the enrichment approach. And I submit that that is correct, that is the right reading of his judgment, and that is the right analytical answer. Now, Professor Burrows takes the second approach of viewing it as akin to a set-off. But he still considers that it should be applied as a separate offence to set-off. It is not set-off properly so called. It is a separate defence to claims in unjust enrichment, and it should be applied as a general defence wherever benefits go both ways.
What, in every case, or only if there is a sufficient connection?
It might be easier to see how he summarises the principle in his book on the restatement of the law of unjust enrichment.
Thank you.
So that is behind tab 31 in volume 3. And the counter restitution, the way this book works, by way of background, is it sets out what Professor Burrows, in consultation with academics and members of the judiciary, considers to be the principle in a grey box, and then contains some commentary thereafter. And the principle is at page 919. So one sees there are two limbs to the test. The first is the traditional counter restitution is impossible limb, and the second limb is that the defendant normally has a set-off defence for counter restitution of reciprocal benefits conferred on the claimant by the defendant. And just further explanation of that at 920. If your lordships and my lady could read just to the bottom of the page from under the heading 26.2. And so one sees in this And so one sees in this, one sees in this passage, Lord Burrows, or Professor Burrows, taking the decision in Westdeutsche and indicating that it ought to be expanded beyond the situation of a swap to be a general proportionate defence to restitution of unjust enrichment. but that it is separate from the defence of change of position. And that is because it applies even in favour of a fraudster. So even if one party to the transaction is fraudulent, the transaction cannot be unwound without making mutual restitution on both sides. Now, what this passage...
But he seems to recognise that that's a qualified proposition, that it's based on a cross-claim basis. And the qualification arises at the end of that passage by reference to cases in which the counter-conferred benefits prevent enrichment or reduce enrichment. So to some extent he assimilates both elements of the rationale.
Yes, that's right.
Could you help me? I should know this, but who were the advisory group? Is there
No,
somewhere an identification of...
It's at the front of the book, my lord. I don't have the book. It's not, unfortunately, on the pages which one sees.
Could I ask for someone just to let us
Absolutely.
have that in due course?
Yes, yes.
Thank you very much.
Now, what this passage doesn't address is the relationship between, beyond identifying that they are separate defences, it doesn't address the order in which counter restitution and change of position fall to be applied. But that point is only very briefly addressed by Professor Burrows in an extract from his textbook behind tab 30, which is the tab before. At page 915. And the extract that one sees here, it is just starting in the second paragraph up from the bottom, which starts with "it seems clear."
I'm sorry, I was writing. Can you just give me that reference again?
Yes, of course. It's volume 3 of the Authorities Bundle,
Yep.
tab 30, page 915.
Thanks. It's just the last sentence of that paragraph. Indeed, to avoid unnecessary confusion between the two, and to enhance clarity, counter restitution is best applied before going on to the change of position defence. And so that is why I said earlier in my submission, it doesn't follow that simply, if one were to take the view that counter restitution is not concerned with enrichment, but is instead concerned with pragmatic tying together of two claims, then it doesn't necessarily follow that change of position would fall to be considered first.
How does that fit as a matter of logic, with the rationale being one of claim and cross-claim where you have a set-off, for which one would more naturally think that you apply defences to claim and cross-claim before you apply set-off?
Yes.
I don't find it altogether easy to follow.
No, and that may be
how that sentence follows from what gone before.
No, and the principle that may be why it is referred to as enhancing clarity and to avoid unnecessary confusion. And that is a point I will come back to, because if one doesn't adopt a clear rule in this context, it can lead to very complicated questions as to the relationship between a defensive change of position on the one hand and various other components of the claim. And one sees that from Mr. Justice Foxton's judgment below, which I will come to shortly. And so it may be that is what is driving that sentence. Well, just to complete the academic.
Sorry, would you just pause for a moment while I make a note of that? So your submission is that what Professor Burrows, as he then was saying, was although that might not follow as a matter of logic from the nature of the justification of the principles of counter restitution, it was justifiable to do things in those orders, in that order, for the purposes of providing certainty and clarity. Is that?
Well, I wouldn't venture to make any submission about whether Professor Burrows thought it didn't follow as a matter of logic.
Well, that's why I was pressing you on
Yes.
that, because I'm speaking entirely for my own part, struggling to see how the cross-claim rationale can justify doing change of position defence first and then counter restitution. If you think there's a way in which it can, I'd very much like to hear it. If not,
My Lord, I will
then I
reflect.
think you are driven back to your explanation that it's for the purposes of clarity and certainty.
Yeah, my Lord, and I will reflect further, but it's what is evident from this passage is the focus is on clarity and certainty. That is what one gets from this passage. Now, just the last, to complete the academic summary, just so that one has the full picture. There is also extracts in the bundle from Professor Edelman, and now Justice Edelman of the High Court of Australia, and Professor Bant, who take the view that was taken below, which is that one looks at the claims independently of one another and applies the change of position defence to resolve those issues. And now, in my respectful submission, that is not consistent with the authorities that I've looked at so far, and it does produce unjust results, and I will come to that very briefly. So that is they are in my respectful submission the outliers in the academic camp, and their view should not be followed. Now, standing back then, having looked at the authorities and the academic material, there are three principled reasons why the result which I contend is the right one. And the first is the mutuality point which I made earlier, which is that where benefits are conferred pursuant to an exchange transaction, there is an element of mutuality involved in the bargain. And that element of mutuality should be carried through in unwinding the bargain by reducing the claims to a single claim for the net benefit, a single enrichment. The second is that if
Sorry,
one...
can I just make a note of that? Where the benefits are pursuant to an exchange transaction,
Yes.
the mutuality in the bargain means that it should be unwound by
mutual restitution.
Can I just, sorry to hold you up, explore the extent to which you accept that that's a principle which must depend upon the particular nature of the contract, the nature of the benefits, and whether they're properly described as an exchange transaction or mutual benefits. There's a danger in using these epithets
Yes.
generally. In the, I know you say that's not this case, but in the case of periodic hire of a chattel,
Yes.
I don't myself see it as self-evidence that one's talking about benefits which are part of an exchange transaction, if they relate to different periods, or which are mutual if they relate to different periods.
Yes, yes. One could see that, and it may be that in certain circumstances that it is right to look at a transaction as comprising more than one exchange. And I wouldn't want to suggest otherwise. So naturally there will be a question as to the ambit of the exchange transaction, and that will be informed by the terms of the contract. But your Lordship has my point that in my submission this isn't a case of a standard hire contract.
No, I'm only pressing you because that may be a principled reason where it fits the facts.
Yes.
for doing netting off, but it may not be a justification for all payments either way under a single transaction being netted off before you get to change of position defences.
It may defend. It may be that what matters is how one characterises the transaction. So the principle in my submission is clear that there must be counter restitution of mutual benefits conferred pursuant to the transaction. That is the exchange transaction in question. But inevitably there will be cases where that requires further analysis to identify the relevant transaction and the relevant exchange. And my submission in this case is that there is only one transaction and there was only one exchange.
Yes.
The second principled reason is that treating this type of claim entirely independently of one another can cause real injustice and outcomes which are manifestly unfair. And one can test that in this case by looking, if one were to look at the two transactions, the two sides of the bargain entirely independently, then one could start, on one view, with the claim by the college to recover the amount which it had paid over, the 3.2 million. And the judge held that SFM had a change of position which exceeded that amount, and so that claim would have failed in its entirety. On the other side of the equation, SFM might say, well, we conferred the benefit of the use of the property throughout the entire period on you. That was a benefit which you received at SFM's expense. It was unjust because the contract was void from the outset. You have no defence, and so you should pay higher for all of the periods, even though you've already paid for some of them, because you can't get your payments back. And so that would result in an absurd outcome on the facts of this case, because it simply cannot be right that the college could be required to pay not only once, but twice in respect of the same use of the property. And the judge clearly did not think that was the right answer, because in respect of the periods where payments were made both ways, his lordship did, in substance, net off the transactions, and I will come to that. And so his lordship recognised that it would be very unfair to treat the claims as entirely independent of one another. But the judge took a halfway house approach, which involved treating them as looking at them year by year, netting off for each year, year by year.
Yes, the judge said in those circumstances, SFM can't claim for the benefit that has been conferred by the use of the building during the periods in respect of which the hire was paid.
Yes.
And that doesn't involve any very difficult analysis to bring it within the principles. One can say that they haven't received a benefit in the value of the use of the building for that period if they've paid for it. It's in the same way as one might say, if A agrees with B to pay £20 for gold which is worth £20, you wouldn't really describe either party under that contract as having received a benefit as a result of its fulfilment. It's not an absurdity.
No, but the contract
but it can be accommodated perfectly sensibly within the application of what is a benefit, or possibly, if the second stage allows a view of what's just or unjust, within the injustice provisions. That doesn't mean that it's necessarily absurd to regard SFM as entitled to recover for use of the building for a period by reference to which payment has not been made by way of hire.
Yes, I was testing the proposition is that if one were to look at the two claims independently, and I do say that the counter restitution principle actually provides a better analytical answer than that which the judge gave for the first periods, and one can come to that when we look at his judgment. But it is clear that it would be absurd if the college had to pay twice for the use of the building during the relevant period. And so at least to that extent, then the transactions must be looked at in an interrelated way. And even on the judge's analysis, that's what happened, because the judge looked at one claim and then turned back to look at its effect on the other. So there is an inherent link in the transactions anyway. And if one doesn't take that into account, the outcome at its extremes would be manifestly unjust. The judge took one approach to resolving that issue, but in my submission, the right one is the counter restitution principle.
Well, like you said, the judge was applying the counter restitution principle,
Indeed.
but he was only applying it to the extent he regarded the benefits and the counter benefits as a mutual exchange.
Yes, that
That may be one way of
indeed.
looking at his rationale.
And my lord, one doesn't get that with fairness, and for understandable reasons, in the judge's main judgment, but that is certainly in the consequential judgment, how the point is explained. And so that does show that to some extent, in substance, what the judge did was apply the counter restitution principle here, but on a year-by-year basis, treating each year as a separate exchange transaction. And I will, you already have my submission that was wrong on this particular case, and I will come to that.
If you're moving on to, how do you want to do it?
I was exactly going to move on to look at the judgment, and so that may take me longer than there is between now and lunch. So that might be a good time for lunch.
Right, thank you very much indeed, Mr. Watkins. So we'll rise now and we'll come back in at 2 o'clock. Thank you.